Right, good afternoon everyone. As Andrew has said, I'm going to sort of shift the dial a bit in terms of what we're looking at. We've heard a lot about the criminal process, but actually one of your, if not the most important assets for any transport business is your operator's licence. And all of what we've heard about today potentially has significant consequences for that. So I'm going to set the scene, and actually the Traffic Commissioner's just walked in before I've come on stage. So whenever the Traffic Commissioner's looking at you as an operator, the starting point is all about trust. If you go way back to the beginning when your operator's licences were first granted, one of the directors or partners in your business signed a set of promises to the Traffic Commissioner about how you would manage your transport operation. And they are the undertakings on your licence. And whenever anything occurs, no matter how minor or how serious, as we've heard about today, it brings that question of trust right back to the forefront. Can the Traffic Commissioner still trust you to operate your vehicles compliantly despite what's happened? So I want to sort of flip things on their head and take you back to the beginning, because no public inquiry should come as a surprise to anybody. There are always red flags or triggers on that journey to public inquiry that provide you with a golden opportunity to avoid getting there, or if you do find yourself there, put you in the best possible position to avoid the more serious forms of action. And just to set the scene in terms of action, last year, for both goods and PSV operators, there were 970 public inquiries across the country. How many of those do you think resulted in revocation of the operator's licence? What proportion? Not Mr. Dorrington.
It's not those set apart.
Almost a third. So for most businesses, that's business ending. What about suspension or curtailment, a reduction in your numbers? All action that will significantly affect your operation. 2/3. Just 6% nationwide had no action taken. And on your patch in the West Midlands, that stat was even slimmer at just 4%. So what I'm going to talk to you about now in terms of that journey to public inquiry really is your golden opportunity to put yourself in that 6%. So first of all, this is the utopia. Proactivity. Now there's a word. How many of you, after you've heard what I have to say, would put yourselves in this category? Regular training on your operator's licence obligations at all levels of the business, from board down to drivers and back up again. Independent auditing to give you a fresh set of eyes, both as a transport manager and importantly as a director or partner, on how you're actually performing. Are you compliant? Are you where you think you need to be? Or are you missing something? And what about visibility of compliance? Does your compliance data get stuck at transport management level? Or do your directors actually get that information about what your OCRS rate is, what your MOT pass rate is, whether you've got any risk areas that could start that ball rolling towards public inquiry? Now that's the utopia. Unfortunately, the majority of operators that I deal with, and I'm sure Mr. Dorrington sees at public inquiry, don't fall into that category. This is the key trigger. So if you don't remember anything else that I have to say, that green box is your one key takeaway. The most common issue that leads to public inquiry starts with a roadside encounter of one of your vehicles and one of your drivers. Doesn't have to be something significant like a fatality or a bridge strike or a wheel loss. It could be that a driver hasn't spotted something on their walk round check, but DVSA do. Now, how many times do you think that happens? 8 out of 10 checks that DVSA do at the roadside. That's a hell of a lot, and a hell of a lot of opportunity for you to stop that happening. Now, if that scenario arises, DVSA will issue an S-mark prohibition. What does the S stand for? A significant failure in your compliance regime. So that is your key red flag. We have an issue. We are likely to have further intervention, and we are likely to go to public inquiry if we don't solve this now. Most common S-Mark prohibition issue at the roadside is for tyre defects. It's consistently the number one defect across HGV and PSV. So let's imagine the scenario. Driver's stopped, tyre defect, S-Mark prohibition. What do you need to do as an operator? Investigate that scenario. What's happened and why was that vehicle out in that condition? Why has that driver not spotted it? But don't stop there. It might not just be that driver. Has that tyre been like that for 2 days, 2 weeks, since its last PMI? Has your maintenance provider missed it? Have multiple drivers missed it? Has your tyre contractor missed it? Review the whole piece and make changes to stop that issue arising again. But don't stop there either. If you've got a weakness over here, you've probably got a blind spot somewhere else in your compliance regime as well. Drivers' hours might not be where they are. Are your drivers recording enough time for their walk-round check, for example, on their tachographs? Use this as your opportunity to get that independent audit to tell you where you're falling short and take steps to act now. Because I can tell you categorically, trigger 2 is coming. DVSA will follow up that roadside prohibition with a visit, whether it's in person or whether it's a virtual remote enforcement office interaction, desk-based assessment. You will have an investigation, maintenance, traffic, or both. Typically 2 weeks after the roadside stop, so you've not got long to put your house in order. If you haven't acted at trigger 1, you've still got time at trigger 2. The investigation will do what your audit would have done. It will tell you where you've got gaps or weaknesses. Use the opportunity now to address them, because you'll have to respond to DVSA and tell them what your plan is to put things right. And that will all then go to the Traffic Commissioner. Next, you're probably going to public inquiry. If you've done what I suggested at trigger 1, you may avoid it. But likelihood is you've not had much time between trigger 1 and actually this reaching the Traffic Commissioner's desk. He'll want to be satisfied that you've actually done what you said you were going to do. And the opportunity to look at that is that public inquiry. So now we're a little bit further on in the timeline. Call to public inquiry, you've got 5 weeks notice typically of the date of your hearing. And you have to submit evidence of your compliance regime to the Traffic Commissioner's office 2 weeks in advance of that date. So even if you start acting on day 1, receiving that letter, you've got at most 3 weeks. 3 weeks to change systems, build a portfolio of evidence, and send it to the Traffic Commissioner for review. Remember that question of trust that I mentioned at the beginning? We've gone from green, we're heading into amber, because the further we go on in this timeline, the more the balance is starting to shift away from the Traffic Commissioner easily being able to say, I can trust you to get this right, and now, actually, I'm not sure. What about the operators that simply turn up to the public inquiry and make promises about things they will do in the future? So you've not done anything at the green stage, you've not done anything at the amber stage even, but you tell the Traffic Commissioner, if you trust me and let me walk out of here with my licence, I promise I will do X, Y, and Z. How likely is he to trust you? Worse still, we do get the operators, hopefully none of you in this room, that actually ask him, well, how do you want me to solve this problem? What do you want me to do? I can see some of you laughing. It's probably what the Traffic Commissioner is doing internally on those occasions. And finally, even worse than doing nothing and asking the Commissioner what you should do are the operators that do one or more of the above stages, but then fail to keep those promises they've made. So not only have you breached those initial promises you gave when you received the operator's licence, you've had a chance now. Despite those breaches, you've been trusted, and now you essentially throw that back in the Commissioner's face. How likely do you think it is that you'll be trusted the further down that time frame you get? So The key message for me in this journey is act immediately that you are on notice of an issue. Act immediately and effectively to solve the problem, but also look at your entire compliance regime. Because if you do, you might still find yourself at public inquiry, but you're far more likely to find yourself in that 6% with no action. I would like to take credit for those different points that I've just talked you through, but actually, as you'd perhaps expect with lawyers, it's all derived from case law that we are bound to follow, or the commissioners are bound to follow. And this case, Arnold Transport, embodies that old adage of actions speak louder than words. And hopefully, as I've taken you through those different stages, you can see that the sooner you act and have evidence that you have acted, the better for protecting your operator's licence. Now, it doesn't just stop there. It's not about the doing on the ground by the drivers, by the transport managers. The traffic commissioners are interested in what the directors and senior managers of this business actually know, both in terms of their obligations, but actually also what's happening in reality. Are we fulfilling those obligations? It's not enough to say, I have a transport manager, it's their problem, it's their responsibility, I trust them to do it. You are required as a director of any business holding a licence to have sufficient knowledge of the operator licensing regime. So what does that mean? Is it enough to know how many vehicles you operate? Is it enough to know what a traffic commissioner is? No. You need to know what the undertakings are that you've promised to fulfil, and also what you're actually doing to achieve that in practice.
Yeah.
Visibility. Do you actually see what the output is from the systems that are in place? Do you receive information regularly from your transport managers or senior managers above them about how you are performing in terms of operators' licence compliance? I speak to many operators who say, oh yeah, I receive reports, I get a traffic light score, whether we're red, amber, green. What do you do with that information? Do you simply take it at face value? My transport manager says we're all right, so I don't need to worry. Well, how do you know that your transport manager is doing their job properly? I've had a number of cases relatively recently where directors are completely blindsided when the letter to public inquiry lands on the desk, and it will be directed to the directors of the business and it will land on their desk. They should know as soon as one of those trigger events occurs, so it shouldn't come as a surprise to them or anybody else if that public inquiry does arise. It's not enough to be a sort of passive recipient of information. You've got to have an inquiring mind and challenge the information that you're being provided with. If you're being told that your vehicles are all being laid and roller brake tested, look at the records periodically. Ask your transport manager to bring you a file so you can have a look and see exactly what's going on. And as the case Alison Jones and Jones Motors says, constant supervision and monitoring, that's not the transport manager's job, that's the director's job, to constantly monitor and supervise the transport manager. And if that isn't happening and you find yourself in that public inquiry scenario, you will, as directors, be criticised by the traffic commissioner. Now, in terms of the transport manager role, I think from the show of hands earlier, there's quite a lot of transport managers in the room. You will all probably be well aware your role is to effectively and continuously manage the transport activities of the business. But do your directors know that that's your role? Do they know what that actually entails? I think it was Beverly earlier mentioned paragraph 60 of Senior Traffic Commissioner's Document 3. That is a job description for your transport managers. It tells everybody exactly what the general duties of a transport manager are expected to look like in terms of vehicles, drivers, admin and management. Is your transport manager fulfilling that? It should be one of the questions that an audit provides directors with the answer to, or your own questioning as a director provides you with the answers to when you're looking at actually what the transport manager is doing in practice. Now, it's very easy, particularly in organisations where directors have other responsibilities. You might not even be the transport director, the operations director, the fleet director. It's very easy in those sorts of scenarios as a director to think transport compliance is somebody else's responsibility or problem. But actually, when the traffic commissioner is looking at any operation, all directors wear the same hat when it comes to operators' licence compliance. So the commercial director, the sales director, the person that perhaps wants the vehicles out on the road regardless, because then they're making money, they face the same questioning and potential disqualification personally as any other director on that board from the traffic commissioner. And those of you that are transport managers in the room, it's perhaps worth reminding the directors within your business of their obligations when it comes to operator licensing, and that actually, if they find themselves at public inquiry, at least one of them will have to attend. They will be asked questions by the traffic commissioner about what they knew at each of those different trigger points. When did they know they'd hit a bridge with one of their vehicles, for example? And it gets pretty uncomfortable when the first time they've heard about any of these issues is when the call-up papers landed on their desk, or worse, when they finally decide to instruct a solicitor to represent them and the solicitor insists that the board get involved. So make sure there is a two-way relationship between transport managers and directors. There should be that oversight from director level and that information flow from transport managers up to the board so that everybody knows what you're expected to do and equally knows how you are performing in relation to those obligations. Okay, I think that's me done.
Good enough.
No. Ooh, another solicitor on time.
Awesome.
Professional speakers this afternoon. So, any questions for Laura before we go on to the traffic commissioner and be bored for the last 40 minutes or so?
Yes.
One question down here. Charlotte?
So,
Oh, there you go.
do we need? Didn't know if I needed it. So, Laura, just because I know it's not kind of wasn't the content of your presentation today, but if we go back to the scenario that Shifty found themselves in, do you see or can it happen that if something happens like that, fatalities, things like that, that actually that's brought to the traffic commissioner's attention and it could go into a public inquiry in that way as well?
Yeah, that. Fine.
Yeah, definitely. The traffic commissioner's role applies regardless of whether there is necessarily a criminal investigation, criminal prosecution or criminal conviction. But certainly in the event of our Shifty haulage scenario arising where there's a health and safety conviction of a company and some of the fines, the eye-watering fines that we saw on the screen imposed, that is certainly something that would lead to you being a public inquiry before the traffic commissioner, assuming the business survived the level of penalty imposed and was able to appear at the public inquiry. But any convictions, so even the driver's conviction, would be something that you are required to notify the traffic commissioner of. Doesn't necessarily mean that the traffic commissioner is going to call you in, but it would certainly start a process whereby there's a consideration of what's gone wrong and whether or not they need to look at you in the context of your operator's licence. It's very, very often the case that if you have a significant incident or a fatal or serious injury collision, as Charlotte said earlier, the investigation and eventual court process can be some time down the line. It can be 2, 3, 4 or longer years down the line. And in the meantime, you're still operating your business and operating your vehicles. And there's often a question there about what do we need to tell the traffic commissioner at this stage? There's no convictions. We've had this incident, could well be front page news on social media. So that side of it is something that you all really need to think about carefully, because you've got obligations to the traffic commissioner, but you've also got obligations under GDPR. You can't simply write and go, driver John Smith has been involved in this collision, blah, 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 because you've got to have a lawful basis for disclosing that sensitive personal data for the driver. So, as Charlotte said earlier, whenever there's an incident like that, you need to think about the media angle, what's going to be knowledge that the Traffic Commissioner gains anyway, and perhaps it will be in your interest to tell them that there's been this incident, even though there's no convictions yet, but be mindful of your GDPR obligations and not prejudicing the criminal investigation either by committing something to writing that you don't necessarily know to be the case.
Okay, thank you, Laura.